Welcome everybody to week 2 of It's Your Estate. We are doing the estate planning basics session today. Thank you all for coming. Before we introduce our sponsor for today, Chapman University, and the people representing them, David and Lindsay, I want to do a quick housekeeping thing. I'm going to share my screen, and I've got some emails asking where you can find the materials from our website. And like I've mentioned before, your link to your from your reminder attendee sessions will have a link to the materials, but maybe it's hard to find that on the email. But you can go directly to our website, itsyourmoneyandestate.org. Okay, you can go to the Educate or the Workshops tab, but you can just click on that and it'll take you to this workshops page with all these buttons. On the bottom right of the buttons is the materials page. So click on the materials and then determine which series you are needing the materials for. This is for It's Your Estate. Click on that and then you'll see it week by week, all the handouts, and we have also posted the recorded webinar from last week there from week 1. And week 2, we'll also be recording this and posting it. But the presentation handout is right there. Davinda is our attorney who will today, our volunteer, who's volunteering his time to give a presentation, is asked first, and then some of Pete's articles that he has posted. So if you have any questions, you can email me about how to find that again, but this is being recorded, so you can go back and watch this and get an idea of where to find it on the web page. So with that, I'm going to stop sharing, and I'm going to hand it over to Pete to introduce Chapman University.
Yeah, and probably for most of the attendees, they'll know David and Lindsay. You're almost going to be you probably could be the moderator and present the entire program. They're one of our longest sponsors and promoters of the workshop series. I'm just so proud to have Chapman University. They lend so much credibility to our program. And so it's greatly appreciated, their sponsorship. David, Lindsay, tell me a little bit about what is the Chapman mission and why should we as a Orange County resident or a person here be interested in Chapman?
All right, well, fantastic. Thanks so much, Pete. So the mission of Chapman University is really all about personalized education, and that personalized education is an education of distinction that leads to inquiring, ethical, and productive lives as global citizens. And so that's what Chapman is about in that regard. So that's our focus and our mission. I know many of you, if you're here in Orange County, you've known Chapman for a very long time. And matter of fact, many of you probably still think of Chapman College as we were for so long. When we first moved to Orange County, but we became Chapman University in 1991, and a lot has changed in that period of time. And so I've asked my colleague, Lindsay Jacobs, to share just a few updates about, so you get a sense of where Chapman is today. So Lindsay?
So as David mentioned, Chapman certainly has grown since being Chapman College. We have about 10,000 students who are on our Orange campus and our Binker Health Science campus in Irvine. So that's part of our growth. And in 2019, US News and World Report actually moved us from being in the regional category for how they rank colleges and universities, and we are now in the national category. And this year we were ranked number 124, which is actually in the top third. So right away we were, playing with the big boys, I guess, Harvard, places like that, we're being ranked among them, and that's really important to us. some of the things that I love to brag about, our dance program is actually ranked #1, and we're growing that program. We're building a new dance building so that this flourishing program can just continue to do amazing things. Our Dodge College of Film and Media Arts is actually #4 now, which is really exciting. And our Ardress School of Business and Economics is actually ranked in the top 100 in the country. And so all of these rankings are across the board. We are just flourishing in all areas of study, and it's fun to watch the students. One of the areas that we've really grown in the last couple of years is our research. We're actually now an R2 status for the Carnegie classification for research. And what that means is we're doing a lot of it. And what I love about Chapman, and you can hear the students talk about it, they get so excited, is they get to do research from day one. So one of those programs that is really interesting is called the Grand Challenges Initiative. And students in our Schmid College of Science and Technology and our Fowler School of Engineering form teams, and they just tackle some of society's most vexing problems, how to solve water crises. And one team worked on how to prevent distracted driving, just things that are big, and then students dive in and they work on it for, sometimes their entire time at Chapman, and it's really fascinating. And of course, Chapman started as a liberal arts college, and we still hold that very close to our hearts. The liberal arts are still very important. And so we actually have a Phi Beta Kappa honorary society that focuses on that, and is something we're really proud of. So we're very well-rounded, and we're growing, and really proud of what the university is doing.
What I hear, Lindsay, as far as feedback is concerned, a lot is the ratio of students to professors. How big are the classes? You're talking about how much you've grown, but is the class size? What's your typical class size?
You would think that the class sizes would be getting bigger, but really our average class size is probably about 22 students in the class. Sometimes, I've had classes with 10 students. I'm a Chapman alumna. I had classes with 10 students. I think the largest class I had maybe had 25. Wow. So they do still keep it personal. Professors know their students and encourage them to take up office hours. And I felt that very much as a student. I know it's still happening for our current classes of learners.
Yeah, it's pretty awesome. The other thing too is that you guys provide a lot of community services that's free to the community. Since this is we're doing the It's Your Estate class, talk a little bit about the internship program and the law school that you have on campus.
Sure. David, do you want to take this one?
Sure. I'll jump in here. So at Chapman University, Pete's referring to our Alona Cortese Elder Law Clinic, and so our Elder Law Center. And it's a hands-on practical experience for our law school students at the university. So in our Fowler School of Law, and those students are under the supervision of a faculty member, can work with and a practicing attorney works with members of the community on issues that are affecting them, and these are all elder law related issues. And so it gives our students an opportunity to have hands-on experience working with an attorney, guiding them, and it provides free legal advice and free legal services back to the community. And so anybody that's interested in reaching out or finding out about how the Elder Law Center works, should definitely reach out to our Fowler School of Law at Chapman University. You can do that by visiting our website. You can also visit the Legacy website, which Trevor has been clicking around and showing a little bit of Chapman's site here while we've been chatting. And so you can go to there by going to chapman.edu/legacy. Or if you go to chapman.edu, then you can find any part of the university you're looking for, including our Alona Cortese Elder Law Center.
I must say that your legacy planning website is very thorough with a lot of resources. And so even if, you know, if you're just looking for information, this is a wonderful place to go.
Yeah, we're going to do an entire session on charitable planning, but I want to just kind of back up what Trevor said as well. If you just need information on charitable gift annuities, charitable remainder trust, both Lindsay and David have specialized knowledge that most professionals do not have in regards to setting up any kind of a charitable plan. And so if you need some feedback and support in that area, they have what's called a Crescendo software program that they can give you some gift information as to what your tax deduction will be, what kind of income you would receive. All of it is done by email, and there's absolutely no obligation to make a gift, and the cost is absolutely zero.
That's exactly right. That's exactly right. And so we're pleased to provide information to anybody that has questions without obligation.
Yeah. Anything else you want to add, David or Lindsay, before we get started in our program?
You know, I'll just say that Chapman's really blessed that we have a really large community of people that believe in our mission and support us, and that's incredibly important. And I encourage everybody that, you know, if you don't know Chapman University, get to know us. You know, our Hilbert Museum of California Art, which is a free museum, it is open to the public right now, so you can actually come in. I believe they're open 11 a.m. to 5 p.m. Tuesday through Friday. So right now it's just on weekdays, but we hope to be returning to a full regular schedule as soon as we can safely do so. And right now we do have some. You're welcome to visit. We'd love to have you visit the Hilbert Museum, and so we're just really blessed and in a fortunate way. And if you're interested in ever making a meaningful difference for others, in doing something with Chapman University, in funding a scholarship or learning more about the university in any way, Lindsay and I are here to help you out and make those introductions. Thanks so very much, Pete, and thanks so very much. I look forward to the program.
Thank you, David. Thank you, Lindsay.
Okay. I'm going to bring up Davinda's Ask First, Pete. And just so everyone knows, if you have questions, please go ahead and type them into the Q&A. I will be answering them as we go. And there also may be questions where I will interrupt the presentation at a proper time to get your question in. And if I don't get to your question, I'll type it in, I hope. Try to get to all the questions. So please ask questions along the way.
Just so, Trevor, so that everybody knows that on your screen, you can have a side-by-side speaker view, you can have a standard view, or a side-by-side gallery view. So it's in the right-hand corner of your screen on Zoom, if however you want to do it. So that's available to you. All right. Are we ready to get into the program?
We sure are. Davinda hasn't bailed yet. He's still there. So
I'm still here.
What is the website to find the Chapman Legacy Giving options? I'll let Lindsay or David answer that. Davinda, welcome.
Thank you for having me.
You're welcome. I'm pleased to have you here. First of all, you're going to pronounce your last name for me?
I should probably pronounce my first name too. You said it perfectly. My first name is Davinda, but most of our clients call me D. It's just much easier. Last name in America, we pronounce it Wijemanne, but in Holland, it's actually a Dutch last name. They pronounce it Wijemanne. But for all practical purposes, it's Wijemanne.
Okay. Well, I'm Dutch as well, and we don't look alike.
You know,
so tell me a little bit of the history, how you got to be Dutch.
So my parents are from a country called Sri Lanka, and it was an Aryan race, and the Dutch actually colonized over there. And so some of us have Dutch last names. And so whenever I introduce myself, particularly to people who are Dutch, they'll look at me and say, wait a second, you don't really look that Dutch. And it wasn't actually until I was in my mid-teens that I realized my last name was Dutch. I actually met somebody from Holland, and he was telling me the history of my last name. So it was fairly interesting.
Good. Okay. So let's go to your Ask First form. And you've got a master's or other advanced degree. I'm assuming your law degree is your advanced degree.
Yes. And my law degree from Pepperdine.
The Pepperdine University. So 4 years of legal experience. Tell me a little bit about the firm that you work with, and what kind of law do you practice in the last 4 years?
Sure. So I'm actually the youngest attorney at the firm. The firm's been in existence for 40 years. I think it's 40 years this year. It was established by Jim Roberts. We have 3 active attorneys and 1 off counsel. We have quite a few clients, about 6,000 active clients. We're fairly a volume type law firm, but all we practice is estate planning. We don't do any other types of planning because we find that it's hard to be a specialist in one area of law if you try to be a jack of all trades. So estate planning is really the only type of law that I've been practicing for the last 4 years.
Okay. And I think that's really important when somebody tries to find a legal counsel in this particular area, because I'm sure estate planning, you're still learning as far as
always.
Yeah, because
always.
Family, yeah, I don't know how attorneys do it when they practice in 4 or 5 different areas of law. So one of the lessons today is, in basics, if you're going to find an estate planning attorney, find someone who just does estate planning. Would you agree with that?
I would agree. I've dealt with various attorneys in the past 4 years, and some attorneys who do estate planning, I guess, as a side gig. They're not privy to the types of laws that they should be privy to. And sometimes I find myself, explaining the laws about estate planning to attorneys who've been practicing for 10, 15 years.
Yes.
And it's not their fault. It's just because they might do personal injury law, estate planning, contract law, real property law. So especially with estate planning, and you probably know this, it's extremely politically contingent. So if you don't have especially when we get to the tax ramifications, so if you don't have the time to keep up with the current laws because you're practicing so many different types of laws, you just really can't be a specialist at one type, particularly with estate planning.
And you also appear in court on estate planning matters as well. So you have the judge's opinion as to their decision-making process, which helps you out with other clients as well.
Absolutely. Yep. Absolutely.
Okay. You do practice law. You have an active law practice. Why is it important to know your bar license, and what does the California bar do as far as you're concerned?
It's very important to know an attorney's bar license, because that's how you look them up to make sure that there have been no complaints. There have been no disciplinary actions filed against them. So I always encourage clients to do research on the attorneys they meet with prior to meeting with them, just to make sure that they're credible and honest.
Yeah, especially in the estate planning area, because of the fact that they team up with a lot of financial brokers and to do these kind of free dinner workshops. And sometimes they're not even state licensed. So you want to look them up, and just to make sure that they don't have any disbarment or issues as far as their license is concerned.
Definitely.
Business relationship, you put your client's interest first. And how do you charge your clients?
Great question. So when we're doing basic estate planning work like trust work or setting up a will or powers of attorney, we do a flat rate. And the reason we do a flat rate is because we know how much work it takes to put together a trust or a will or powers of attorney. So there's no point in billing our clients billable hours, which a lot of people have heard of. It's interesting because our firm is unique in that once you're a client of our firm, you can call us anytime you want and ask us questions, shoot us emails, and you're never going to get a bill for an hour of time, which is really neat because a lot of attorneys, if you call them or email them, they'll send you a bill a month later with billable hours. And we really don't operate that way. The only time I really do operate that way is if we're going into court, because I can't predict how long it's going to take, how many supplements have to be filed, when the hearing date is, you know. So if we're going to court, we'll sometimes bill hourly, but for the most part, it's a flat rate.
Okay, so let's say I have $1 million estate, married, couple of kids. I need to do a basic estate plan. What would it cost me?
If it's a basic estate plan with the trust, will, healthcare directive, financial power of attorney, HIPAA form, trust certification, any deeds for properties, the flat rate is $2,450 for a joint estate plan.
And if I was single, how much would you charge?
$1,750 for an individual.
Okay, and you said that if I have phone calls, questions, those are not billed on an hourly basis, so that is just part of the package?
Correct. So once you're a client of ours, we don't bill you for any questions or anything like that. But for clients that just have questions, or for individuals that have questions that aren't our clients, we'll always give them a complimentary 1-hour review or consultation. And then beyond that, if they have questions and concerns and they're not yet clients of ours, sometimes we will bill them because they're not yet our clients.
But you would let them know
Absolutely.
upfront that you
100% we have to.
Okay. If somebody wanted to come in and say, hey, I would like for you to review my estate plan, will there be a charge for that?
No charge for that. And to be honest with you, our firm, we do a good job of telling clients that if their estate plan is in order, they don't need us. About 3 clients in the last few weeks have come in. We call them foreign trust reviews. They're trusts that were put together prior to meeting with me. And about 3 of them in the past 2 weeks, I told the clients, I said, well, thanks for coming and seeing me. There's nothing I can do to make this better. And I'll be honest with you, there's nothing to do. We're not going to charge you for nothing.
There's a lot of times when you do need to make a change, let's say in a trustee situation. When, let's say there is a change in trustee, would you then let the person know that this is going to be the cost?
Absolutely.
Okay.
Yeah.
And then people, I don't think realize this, but when you make a change in the estate planning document, you're going to be responsible for the entire document. So sometimes, then it's easier to do a restatement of trust. I know we're not into the program yet, but talk a little bit about that, about making some changes in a trust as an amendment or doing a restatement of trust.
Sure. So honestly, most of the time I do restatements. A restatement is kind of an overhaul of the trust, although it does keep the original name and date the same. And that's important because when you keep the original name and date of a trust the same, you don't have to refund the trust. Everything you've already put into there will stay the same. But a restatement is a huge overhaul. So for example, I met with a client yesterday who had an AB trust. It's a type of trust that they did in the 90s for tax purposes, estate tax purposes, that they no longer need today. And so it would be too difficult to do a basic amendment. So I have to do an overhaul of the trust, which we call a restatement. So it's basically like a new trust. When you do a restatement, it just changes the name and the dates is the only thing that stays the same. With an amendment, however, if it's a simple change, for example, I set up a trust for a client last year. This year, they just wanted to swap their successor trustees. There was no point in doing a full restatement for one simple change. So in that situation, I just did an amendment.
Yeah, but if you have, if your estate plan starts looking like the IRS,
that's true. Then you're going to want to do a restatement to kind of consolidate everything into one binding document.
Yeah. You don't want to make the your estate planning document such that you need to have reference points and tabs in order to keep.
You are absolutely right. It makes it extremely difficult for the successor trustee when it's time for the administration of the trust, because now they have to refer to 5 or 6 different documents. So it's a great point, Peter. We had a client who had about 9 amendments. And so I looked at, this was a little while back, I looked at this and I said, you know, I have to look at each amendment to figure out what to do here and there. Why don't we just do a restatement and put it all into one document? And in that case, it's so much better to do a restatement. Simple
is better than complexity, because you want people to understand your wishes.
Absolutely. Absolutely.
Okay, this is going to be the estate planning basics. Davinda is going to give us an overview of the estate planning area. That does not mean that Davinda can't do a complex plan. He knows that we've got other attorneys doing different sections of an estate plan. So he's going to just stick to the basics today, but he'll be able to answer any of your questions on no matter pretty much any kind of the complexity of an estate plan. So let's go to the first page.
So I'll do that. So if anyone wants to get a hold of him, at the bottom of his ask first is the contact information.
Oh, I forgot to ask. Davinda, you put false, but you're not associated with anyone for referral fees or selling annuities or mutual funds, financial stuff.
Correct. Yeah, it would be a conflict of interest. According to the state bar, we're just not allowed to do that.
Okay. All righty.
So Davinda, I'm going to stop sharing and then go ahead and you can bring yours up. Let's see.
Can you see my screen?
Yes.
Yeah.
1 second. Let me try this one more time. Okay.
So you might want to full screen. There you go. That looks great. Okay.
Perfect. And let me move this. There we go. Okay. So can you see my screen okay?
Yes.
Okay, awesome. So we kind of went over my name and the basics and my history. So today, as Pete was saying, we're going to discuss estate planning basics. We're not going to get into anything complicated. I think that's going to be reserved for later sessions, but we're just going to go over the basics of estate planning. And a little overview of the presentation. We're going to start with conservatorships, and then we're going to then discuss what probate is. Many of you probably already know what conservatorships and probates are. We'll talk about the advantages and disadvantages. Then we'll get into beneficiary designations and title of property and how that could actually help avoid probate without creating a trust, what a will is, personal property distributions. Then we'll touch on various tax considerations. There have been some changes in the law recently regarding property taxes, and there's probably a change regarding the estate tax that's going to occur fairly soon. And then if we have time, we'll talk about what estate planning is and how it can help avoid probate and conservatorships. And that really gets into like powers of attorney and trust planning. I don't know if we'll have time to fully cover the last topic, and that's okay, because as I understand it, you're going to be covering those topics at later presentations anyway. So the main goal is to get through the first few.
Yes.
Now, the first topic is conservatorships. And before we kind of get into what conservatorships are, I'll give you an example of something that personally happened in my family. When my grandma was like 91, 92 years old, she started showing early signs of dementia, and then progressively it got worse when she turned 93 and 94. She didn't have any sort of documentation or estate plan in place, and so when my mom stepped in with the intent of helping my grandma pay her bills, manage her finances, and manage her healthcare decisions, she couldn't do that because we didn't have anything that would allow my mom to have legal ability to take care of my grandmother. So what my mom had to do is she had to file for a conservatorship with the court. And what that is it's an appointment by a judge that gives an individual power over the finances and the estate of an incapacitated individual. So my mom had to actually file through an attorney to get conservatorship to help my grandmother. I think in it was in 97. And back then it only took like 2 months for her to get it, but it ended up costing her around $5,000 or $6,000. Today, the fees to get a conservatorship for an incapacitated individual might be closer to $5,000 to $10,000. I would actually err on the side of $10,000. So it could be extremely costly. And it can also take several months to obtain. The California courts, especially due to COVID-19, are extremely backed up. We've had hearing dates last year that got pushed to the middle of this year and that have been pending for a year and a half. So getting a conservatorship can take a lot of time. And that's not good, right? Because if you need to take care of an individual who's mentally incapacitated, how can you possibly wait 5-6 months to get access to their assets to assist them? So having a proper estate plan can avoid that. It'll give you the legal documentation so that when the time comes, it won't take very long for you to get the power to help that incapacitated individual.
Yeah, Davinda, it's the same similar circumstance that my father was in the hospital, and myself and my 3 sisters, we kind of disagreed as to the kind of level of care that my father ought to receive. And the question was posed to us is, who's your father's healthcare agent? Who has the legal authority to speak on his behalf? And
right.
We didn't have any of the documents. And
right.
So most people think of estate planning as something you do for after death. And
right.
I believe that the incapacity aspect of estate planning is 10 times more important because you're alive. And
Pete, I completely 110% agree with you, because getting estate planning done to make sure you're taken care of later in life, to me, that's more important than where your assets go after you pass away. Yeah. Your beneficiaries or your heirs will eventually get your assets, but when you really need that help later in life, I think estate planning is most important for that aspect. So I completely agree with you.
Yeah, and the conservatorship today, it's almost now $10,000 plus. And with COVID right now, the Orange County courts are so backed up. It's right. 6 to 8 months before you even get into have a hearing. So one of the things we're going to be talking a little bit more on conservatorships next week, but let's go into your next slide.
Okay. Now the next slide is probate. Most of you have heard of probate. It's a supervised process that your assets go through after your passing if you don't have, I shouldn't say proper estate plan, but an estate plan that would avoid probate. And that's okay sometimes. There are some advantages to probate. In the next slides, I'll go over advantages and disadvantages. But just to kind of simplify it, if I were to pass away with no estate plan in place, my assets would go to the court system, and the court would be responsible for distributing the assets to my heirs. Now, when that happens, a probate referee is appointed. What a probate referee does is they step in, they evaluate, appraise the assets, inventory the assets, and figure out what the estate worth is. I'll go over this also, but creditors also have to be notified in the probate process. So if I pass away and my assets go to the court, one of the first things the court does is they notify my creditors to let them know I've passed away, and they kind of get that resolved. There are court administrative costs. I'll delve into that a little bit more in depth in one of the other slides. And in addition, attorney's fees, I'll also talk about that as well in one of the other slides. But before we get to the disadvantages of probate, there are advantages of having a probate. For example, there's no upfront cost. Setting up a trust at our firm costs $2,450 for a joint couple. But the situation is, over time, it's actually going to end up being more than that. For example, I had a client who's amended their trust or restated their trust 7 or 8 times in the past 20 years. So they've actually paid closer to $15,000 to $20,000, right? Because every time they make changes to their trust, they have to pay a fee. You don't have to incur that fee if you don't set up the drafting for an estate plan like a trust.
In other words, your will is not effective until your death.
Exactly.
Whereas a trust is effective immediately when you sign. And so it needs to be updated on a regular basis. Whereas if you had your basic advanced health care, your power of attorney, and your will, those documents are probably need less updating as you get older.
Absolutely, definitely. And it's easier to update those documents than it is to update a trust. So you save quite a bit of money on those updates. And then
talk about creditor.
Yeah, so in California, the statute of limitations for a claim against an estate is 1 year. What happens is when you're carrying out the duties of, let's say, a trust, the successor trustee is responsible for safeguarding the funds for any claims against the estate for up to a year. So distributions or full distributions might not happen until after a year. I've seen that happen before. But when assets go through probate, the court notifies the creditors and pretty much gets things in line. So we don't really have to worry about that 1 year time frame. So the court will resolve the creditor situation.
So it's shortened to about 3 to 4 months, I believe.
Yeah, which is much shorter than 1 year, right? And then the next is attorney and executor fees. Now, those are only paid at the end of the administration. So you know how we were talking about initially where you have to pay money to set up, let's say, a trust, and then you amend it periodically throughout your lifetime. You could end up spending $15,000 to $20,000 to $30,000 throughout your lifetime updating it. For assets that go through probate, there's no fees until after the probate is complete and the assets are distributed. Now, the next point is, in my opinion, the biggest advantage of probate. Now, in order for me to kind of explain why this is an advantage, let me kind of briefly just go over the obligations of a trustee for a trust. When you're a trustee for a trust, you have a fiduciary obligations to the beneficiaries. So trustees are consciously concerned about breaking the law or incurring a liability that could get them in trouble. And they don't really have the support of, well, they have the attorney support, but even then trustees can make mistakes. So they're always conscious about liabilities and things like that. The neat thing about when you go through probate and you're an executor of a will, the court basically guides you. So the liability risk is so much smaller when you're going through probate. And that brings us to the last bullet point. And that's because the judge basically controls the distributions and the order and the process of the probate. And one of the biggest things I see with assets that aren't going through probate is internal fighting between beneficiaries. Trevor's helped me with a lot of those cases, actually, where it's a pretty straightforward situation, but the beneficiaries make things so difficult. When you're going through probate, it's a lot harder for a beneficiary to argue with the judge than it would be for a trustee, if that makes sense.
Yeah. First of all, Davinda, thank you so much for putting some advantages of a probate, because you don't hear that very often. And you're going to go through the negative parts of a probate, but at least people now have a better understanding that there are some advantages, because you're changing title to assets, and to have a court oversee that process and make it formal sometimes is better than the informality of a trust. Let's go to the next slide.
Perfect. Now, disadvantages of probate. I'll touch on these more in depth on the next slides, but the three main disadvantages is time, cost, and lack of control. But to be fair, even if you don't go through probate, administrating a trust, for example, can still take 1 to 2 years. So, and then the cost, we covered that. Even if probate can be expensive. It can be very expensive. But even if your assets go through probate, there are upfront costs to avoid probate. So in the end, it's kind of a cost benefit analysis. And then lack of control, and we'll kind of touch on that as well. But let's start with time. And I'll be honest with you, it depends on from county to county, Pete. I mean, in California, they say the average probate process takes 1 to 2 years. But one of our attorneys just completed a probate in, I think it was San Bernardino County, and it only took 4 months. Now, I don't think that's common. It usually takes a little bit more than that. The estate itself wasn't particularly high in net worth, but sometimes it can take less than that.
Yeah, but in COVID time right now, it's probably, if you were to have died last year or the year before you just had started, it could be 2 years.
You're right. I had hearing dates for petitions I filed at the end of 2019, and I filed the petition at the end of 2019, and then I had hearing dates in March and April, which is, the worst time for the pandemic. They all got continued to the end of last year, but then the courts were still backed up. So a few of them actually got recontinued to this year.
Yes.
So it could take quite some time.
Yeah, and everything is being done on Zoom. The courts aren't open yet. Hopefully, in the next couple of months, that'll change.
Yes, I agree. But the reason why it does take some time is because they have to appoint a personal representative to the probate. They have to inventory and appraise assets.
A personal representative, personal administrator, executor.
Executor.
Okay.
Right. Yes. So if you have a will, the executor would fall into the personal representative.
So the executor's role is just like a trustee?
Very similar, exactly. The only difference is the executor has to work with the court in the probate process, whereas when you're a trustee, you don't work with the court. You kind of do everything on your own. And that could be a benefit, that could be a disadvantage actually, because you don't have court guidance. Whereas in probate, you have court guidance. And that goes back to the situation where your liability is just reduced when you go through the court system and go through probate, because you do have the judge's backing and the court backing, and you have that guidance and avenue on where to go next.
Yeah. You have to do a formal inventory and appraisal.
Yes, you have to do a formal inventory and appraisal of assets. A lot of the times, though, I believe the probate referee is the one who does the appraisal and gets the inventory of the assets.
And how much does that cost to have a probate referee value your assets?
I believe, and correct me if I'm wrong, but I believe it can cost upwards of $3,000, right?
Yeah, it's they charge on the value 0.1% on the value of what they're being appraised at. So there is a cost. It's not an immense, but you have to do the same thing in a trust. I mean, everybody, the beneficiaries want to know what is the stuff in the estate and how much is it worth.
Exactly. So even regardless of whether you're going through probate or not, you have to do that. And with a trust, you have to, a lot of the times, do a formal accounting through a CPA, which could cost $5,000 to more. So that cost will be present, I think, regardless of what you're doing, whether it's a probate or a non-probate issue.
We're going to go through what is a will and why do you have to validate a will, if you have one?
So what happens is when it goes to the court, they have to make sure it was legally drafted, not drafted, I shouldn't say drafted, that it's legal. So a lot of the times, for example, a holographic will, which I'll touch on later, is a handwritten will where you just sign it with no witnesses. And that is actually valid in California. A lot of states don't view holographic wills as being valid. But the reason you have to validate it is because you literally have a handwritten document that's just signed. So there's so many question marks. Like, did the testator, the person who wrote the will, was he actually the person who wrote the will? Or was there undue influence, somebody telling them what to do? Did he write this when he had diminished capacity, like Alzheimer's or dementia? So you need to validate the essence of the will before you can carry out its effect, if that makes sense.
We always think that that the handwritten will is written by somebody who is unsophisticated. Yet, the famous case is Howard Hughes left his entire fortune with a handwritten will, and I don't think that ever got validated.
I believe you're right.
But it's a big issue, validating a will.
It is. It definitely is. And there's various types of wills, and some take less time to validate than others. Like a formal will would probably take less time to validate than a holographic will, right?
Yeah.
But we'll definitely get to the different types of wills. I think we have a slide on that.
Yeah.
And then obviously the court has to notify the creditors to file a claim. So what happens is when your assets go through the probate process, the court will spend some time notifying the creditors and resolving that situation. And that can take time depending on how many creditors there are. Then you have to do a final account and then a petition for distribution, basically saying, okay, this is what we're doing. This is where we're distributing the assets. This is the accounting where the money went. Then you actually distribute the assets. And then lastly, you file a petition to discharge the probate estate, and then you're done. And on average, it can take 1 to 2 years. I've seen it happen quicker than 1 to 2 years. But as you were saying, with COVID-19, it's taking longer than it typically does.
Yes.
And actually, before I even move forward, I will say this. Probate is not as big a problem in other states. I'm dealing with an attorney in Colorado, and he was telling me, Davinda, we don't do trust in Colorado. Our probate process is 2 to 3 weeks, so there's no reason for a trust. We just do wills over here. And he might have been alluding to just that specific area.
Well, that brings up a good point, and that is, especially because we're talking about the basics today, is there a national probate law?
The probate, as I understand, is specific state by state.
Yes. Yeah. So every state has different rules.
Right.
So if you have, will a California will control property in Nevada?
So a California will, I'm not sure, Pete. I'm not sure. I believe that you could use the will, though, in the probate process.
You could, but it has to conform to Nevada law.
It definitely has to conform, but I have seen, so I had somebody who drafted a will here in California and had property over in New York. Obviously, New York being the other difficult state here in the United States. But we hired an attorney out in New York to handle the probate process, and they were actually able to use the will to follow the intent of the testator to distribute the assets in New York to the beneficiaries. But the situation in that case, there was nobody contesting it. Everyone was on the same page, so it was a lot simpler.
Yeah.
In that situation.
Yeah. So, but keep in mind that if you just moved here to California, California probate laws are completely different than most other states. And if you move to another state, have your documents updated to conform to that state's laws.
Always, especially because some states are community property states, some are not. So you definitely want to update your documents if you move from one state to another.
Let's go to the next slide.
Perfect. Now here we talk about the cost, and the cost is actually set by a statute here in California. So if the estate, and before I move forward, let me share that this is gross, not net. So if the estate is worth $100,000, the attorney and executor fees are 4% for $100,000. Then it's 3% for the next $100,000. 2% of the next 800,000, and then 1% of the next 9 million. In the next slide, we'll go over a graph so you can kind of see how that works. But for example, if you have an $800,000 estate that's going through probate, you have $38,000 in fees, $19,000 in attorney's fees, and $19,000 in executor fees. Then there's also court costs, and then probate referee costs is what we discussed previously. And then there's other extraordinary costs. For example, if assets go through probate, it can turn to litigation if somebody steps up and contests the will or says this was drafted incorrectly or there was diminished capacity or undue influence. So there are extraordinary costs that can be there down the line.
Do you recommend when a family member comes in to see you and a family member is named as the executor, do they have to take their fees, or can they?
You can waive fees if you're the executor or successor trustee of a trust. I believe you can say you don't want them.
Is there ever a problem when one family member says they will take the fees to the other family members, or is that
there are problems sometimes. Sometimes beneficiaries will say, well, that's not fair, especially if it's a high net worth estate. If you take a percentage, it could be a good payout. So you will run into problems where beneficiaries have problems with the compensation that the executor or trustee is taking.
Is it being an executor? Is it a position of honor, or is there a lot of work involved?
Oh my gosh, there's a lot of work involved. I always advise clients to take the fees. I mean, it's not fun. It's a lot of work. It's almost like a part-time job.
Yeah. So yeah, you may want to talk about it with your family members. If you're going to name a family member as an executor or as a trustee, there's a lot of administration involved, and I would recommend highly that you make sure that the person gets paid for their work.
Right, exactly. And I always recommend that, because why not? You're spending hours and days in your time carrying out the duties of the estate. It's only fair that you get compensated for all that work that you're doing.
Okay, let's go to the next slide.
Okay. So here's just a quick graph about the statutory California probate fees. So if you look at the bottom of the graph, you can see that if you have an estate that's worth $1 million, the attorney's fees will end up being roughly $23,000, executor fees $23,000, for a total fee of $46,000. So you can see how it can be costly if you have a high estate, but high net worth estate. But if you look at the $200,000 value and the total fee being $14,000, this is a good example of how sometimes a probate estate can be less costly than an estate that doesn't go through probate. If you're an individual who has an estate of not only, but $200,000, administrating a trust or creating a trust to avoid probate over many years might end up costing $14,000 throughout your lifetime, whereas it's pretty close to the fees in probate. So a lot of the times, if you have a high estate worth, my strong recommendations are typically let's avoid probate, but there's benefits and disadvantages to both ways.
So when you say gross value versus net, so like say, for example, you just purchased a house and you put $100,000 down, it's worth $1 million, but you only put in $100,000. So are you talking about that the fees for probate would be at the $1 million level, not at the $100,000 that I put in?
Correct.
Okay.
And if there's any liens and debts on the estate, they go off of the gross value.
Okay.
I have a quick question. What is the cutoff of having to, or the size of the estate cutoff having to file a formal probate?
It's actually, so for financial assets, it's $166,250. They just increased it, I believe, last year, if I'm not mistaken, from $150.
Yeah. So anything, if you have an estate under that, you can use what's called a small estate affidavit to transfer assets? Okay.
Yep, you can use a 13100 declaration, also known as a small estate affidavit. And honestly, most banks and financial institutions have their own small estate affidavits you can fill out. But remember, it's $166,250 collectively.
Yeah.
So it's not just one account being less than that.
Okay, let's go to the next slide.
Okay. Now, how to avoid probate and conservatorship. Proper estate planning. And like we said, maybe you don't always want to avoid probate, but if you do, proper estate planning can avoid probate. I generally always recommend let's at least try to avoid conservatorship, because there's no need to go through that time and money to get conservatorship. And when you're setting up a proper estate plan, the main keys are who's going to manage your assets if you become incapacitated? Who's going to make medical decisions for you if you become incapacitated? And then even easier, who inherits your assets after you pass away? And if you have minor children, who takes care of your minor children? And not just minor children, if you have any individuals who are on special needs benefits, having a proper estate plan can safeguard them as well.
Yeah, I find this that your attorney is almost like your counselor. You literally, you need to tell your attorney what issues your children have. There's many of us in society that are schizophrenic, that have a mental illness. We may have a physical illness of stroke or dementia or whatever that you need to know of, because you can put an estate plan together that serves that particular purpose. If somebody has a drug problem, or an alcohol problem, giving them money through your estate may be the nail in the coffin. So maybe there should be some special things to happen. But if you hold back and don't tell the attorney about your children and what issues there might be in the family, then you can't set up a good estate plan. Exactly.
The more information your attorney knows about your particular situation, the better they can plan for you. And at our firm, we even if the client doesn't bring it up, we don't assume that it's because it's not a problem. So even when I have clients coming in to set up their first estate plan, if they don't bring it up, I'll always ask, do you have any beneficiaries who are on government benefits? Do you have any underage beneficiaries, any special needs beneficiaries? So you definitely want to give an overall picture of your situation so that you can plan appropriately.
You got it. Okay, next slide.
Now, so you're going to go over trusts in a different presentation on how trust can avoid probate. But
yes,
what a lot of people don't realize is there's other ways to avoid probate and different ways to hold title that can affect probate issues. And we're going to kind of go over those. And I'm also going to touch on the tax ramifications for each particular subject. So the first one I want to discuss is beneficiary designations. And most of you are probably familiar with that. On your financial accounts, particularly 401ks and IRAs, when you set up those accounts, the advisor typically asks you who you want to appoint as your beneficiary. And if you appoint somebody as your beneficiary and you pass away, we completely avoid probate. So on my 401k, my beneficiary is my wife. So if I pass away, my account just goes to my wife, no probate, right? Because I've designated her as the beneficiary. But let's say my wife passes away also, my contingent beneficiary is my daughter. So then the account would be transferred to my daughter and we would still avoid probate because she was designated on the beneficiary form. And so a lot of clients who come in and see me say, I need a trust. And I sometimes ask them, well, why do you say that? Well, I want to avoid probate. And I'll say, okay, what are your assets? And they might say, I have accounts here, 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 and here. And then I'll ask them, do you have any special situations, any special needs individuals who are underage or individuals who don't have the capacity to control their inheritance? And they'll say, no, everyone's responsible, everyone's adults. I just want to leave my money, my assets to my children. And if that's the case, a lot of the times you don't need a trust. You just put beneficiary designations on all those assets and we avoid probate altogether. Now, just as a rule of thumb, on non-retirement accounts like checking, savings, and life insurance, they're typically called payable on death. Same thing as a transfer on death for investment accounts. Slightly different, but both of them are forms of beneficiary designations.
Right. Make sure if you do, make sure you get a copy of your beneficiary designation form so you can put them with your estate plan, because many individuals forget who they named and when. And so you want to make sure of that. And remember, sometimes it's not a good idea for a special needs individual. You don't want to put them on a payable on death, because now you may be messing with their government benefits.
Exactly. So, and a perfect example of that is my brother-in-law has special needs. So he's on government benefits. He can't have more than $2,000 in his estate. Otherwise, he would lose his SSI or Medi-Cal. Yeah. So leaving him as a direct beneficiary on any of the assets would negate all the government benefits. So if that's the type of situation, then this might not be the best way to go.
So, but for individual bank accounts, you can go to your bank and do a POD. It's very simple. You fill out a beneficiary little form, you put the person's name on there, you sign, and then upon 40 days after your death, whoever you named can go to the bank and take the money, showing proof of their identity. I recommend it for small amounts. You don't want to make your entire estate plan payable on death.
I agree. I definitely agree.
We have a quick question. Someone asked, what if you named your trust as the beneficiary as a transfer on death for 401k?
Actually, I'll be honest with you. Sometimes I recommend clients do that just to make it easier. So for example, my wife has a separate account that she doesn't want my name on. It's her fun account. That's fine. I'm not allowed to have my own account, but she can have hers, which is fine. And she wants that money to go to me if she passes away, but she doesn't want to put it into our trust, because if she put it into our trust, it would put my name on that account. So what she did is she just put the trust as the beneficiary, and it works the same way. If she passes away, I have to present the copy of the trust to the bank, and the money goes to the trust, which means it goes to me anyway. So it ends up working the same way. So you can certainly do that.
You can be, but there's a lot of tax ramifications. And before you do that, I would recommend highly that you talk to a CPA and the attorney before you name a trust as a beneficiary, because of the tax implications.
And you're right. For checkings and savings accounts and life insurance, those aren't taxable.
Yeah.
So for those accounts, naming the trust as the beneficiary is perfectly fine in my opinion. Yeah. But for 401ks and IRAs, you definitely want to consult with a CPA. I generally recommend not leaving the trust as the beneficiary on any qualified accounts. Yeah. I definitely.
Just so you know, we're going to do an entire session, hour and a half, on retirement plans. So,
gotcha.
This is what you want at this particular stage. You want to understand how you own your assets and who is and what assets need a beneficiary designation. So we're going to go through how to have title to all of your assets and the plus and minuses of each, one of them being a living trust as a title to your assets. So let's go to the next slide.
Got about 30 minutes, man.
Okay, perfect. So what we're going to do is we're going to go over the different ways in holding title. Let's start with individually. This is basic. If I have a bank account in my own name, I own it individually. I can put a beneficiary on that. Remember, I can transfer it based on a payable on death, and we don't have any probate. On top of that, let's say I have a mutual fund or a brokerage account that I hold individually, and I have I can attach a beneficiary to that. And the neat thing is that they will get a step up in basis. Now, before I kind of go further, let me explain the step up. If I invest in stocks, let's say I invest $50,000 and I let it sit there for 20 years, and then it grows to $1 million, let's just say, and I pass away, and let's say my wife or my daughter or whoever is my beneficiary on that account. When I pass away, they get a step up from $50,000 to $1 million, which means they can liquidate that account and pay 0 in capital gains taxes. So when you hold accounts individually, sometimes that's a benefit. I've seen clients who have added their children to investment accounts, and that's not a good tax situation because you don't get that full step up in basis. If you add people on, if you add, let's say, children onto your financial accounts. Does that make sense? Pete, do you want to say anything on that?
Yeah, just when you hold it as an individual, though, you better have all of your estate planning documents in order, because if you hold it as an individual and you have to go to court in order to, you end up in a conservatorship if you get ill or mentally disabled or
yes.
Et cetera. So you want to make sure that you have a list of all of your assets, and then right next to that asset, state how do you have title, either as an individual, and we'll go through some of the other titles in just a little bit, and then what is the cost basis of that asset, and what is the market value. So if you have your situation that you just described, where you have a cost basis of a stocks at 50,000 and a market value of $1 million, well, it's kind of obvious that to take advantage of the full step up in basis, you may not want to give your beneficiaries that stock during your life and want to wait at the end of your life so they don't have to pay income taxes on it. And we'll talk a little bit more about gifting in a little bit. I know you have a slide on that.
Yes, yes.
So let's go to the next slide.
And then there's joint tenancy. Joint tenancy is when you hold an asset with another individual together, and that comes with the right of survivorship. This avoids probate because of the right of survivorship. So let's say I own a property with my sister, and we own it as joint tenants with the right of survivorship. If I pass away, my interest is automatically transferred to her, and that avoids probate. Now, it only avoids probate on my death, but if my sister doesn't do anything after I pass away, then it would go through probate on her death because there's no other person that can survive her unless she added somebody else on title. So joint tenancy stalls probate on the death of the first tenant. Also with joint tenancy is there's no full step up in basis like there is if you're an individual owning 100% and leaving it to individuals who inherit your 100%. With joint tenancy, if I pass away, my sister only gets a step up on my half of the interest. So if we bought the property for $100,000 and it grows to $1 million and I pass away, that's a $900,000 increase in value, but she only gets a step up on half of that, which means she only gets a step up of $450,000 because that's the interest I owned at my time of death.
Yeah, it used to be, and I don't know, most people determine how to hold title to property from their real estate agent when they purchase a house. And many of them recommend joint tenancy with right of survivorship,
right,
which in California is probably the least preferable way to hold title, not only because of the step up in basis, but in the example that you just gave with your sister. What if your sister got into a major accident and now
right,
they're coming after her and suing her? Hey, and they find out you're on title. What's
right,
your liability?
So typically when you go through a lawsuit, if I'm still on title with my sister, they typically can only, unless it's a married couple, but they typically can only go after her interest. But that greatly severes my interest because my 50% interest is basically obsolete if they attach a lien to her interest, right? So a lot of the times when you hold assets with another person, then you have to be careful that you hold it with somebody who's legally responsible and doesn't engage in illegal activities.
Yeah, well, I find joint tenancy with right of survivorship done a lot of times with parent and child. Oh, I want to avoid probate. And so they put their children's name on the title.
Right.
And when you put a name on title, you're making a gift, right?
Right.
Of half the value.
Yep. And you have to file a gift tax return.
Yeah. So avoid joint tenancy with right of survivorship as a, you need to think about it before you do.
Absolutely. And I'm going back to what you said before. There's a better way if you're married to hold title in California, and that's right here. So it's funny because what you were saying happened to me when my wife and I bought our property. They didn't even ask me, but they put title as joint tenants with the right of survivorship. I didn't notice until I saw the deed that was recorded and sent to me, and I immediately had them change it to community property. And the reason being is because community property has a tax advantage that joint tenancy doesn't have. First off, community property is very similar to joint tenancy. If one person passes, the entire interest goes to the survivor. The only difference is that to hold your property as community property, you have to be married. You can only hold an asset as community property if you're a husband and wife or spouse and spouse. It still comes with the right of survivorship. So the surviving spouse still gets the interest, but the big difference is it's a full step up in basis. So let's say that I never changed the property from joint tenancy and the property grew. my wife would only get a step up on half of the interest. But since I changed it to community property, if I pass away, my wife gets a step up on the entire interest. So if we bought the property for $100,000, owned it as community property, and the property went up to $1 million, and I pass away, she gets a step up to the whole $1 million, not just half. And that's the biggest advantage.
Yeah. And by the way, you could hold financial stocks, bank accounts, etc., as community property with right of survivorship.
Exactly.
And most property, if you're married in a trust, unless it states otherwise, is going to be assumed to be community property.
Absolutely. Absolutely.
Okay. Let's go to the next slide.
Tenants in common. Tenants in common is different than the previous two titles because it doesn't come with the right of survivorship. It's an interest that each owner owns. That's their own interest. It doesn't go to the surviving member that's on title. So same situation, if my sister and I own a property as tenants in common and I pass away, my interest now doesn't go to her because there's no right of survivorship in tenants in common. My interest goes according to what my estate plan says, or to be subject to probate if I don't have a trust in place. So the biggest difference with tenants in common is that there's no right of survivorship. And a lot of people want to hold title as tenants in common. If I have a business partner and we buy a rental property together, I want to hold it as tenants in common because if I pass away, I don't want my interest to go to him. I would want my interest to go to my wife or my children, right? So when you own title as tenants in common, you want to make sure you have a proper estate plan in place that dictates where your interest goes if you were to pass away. And regarding the tax ramifications, you get a step up on whatever interest the decedent owned at the time of their death. So if I own 30% and my business partner owns 70% of the asset, if I passed away, my beneficiary would only get a 30%. Well, they get 100% step up on my interest, which is great. So if it's sold, they would pay zero on capital gains taxes.
Okay.
And then living trust. Now, a living trust avoids probate altogether. So if I put my assets into a living trust, a joint trust with my wife, if I pass away, there's no probate. You know, assuming it's a general revocable living trust, it just goes to my wife. And then when my wife passes away, it just goes to our beneficiaries. Neat thing about a living trust is you do get a full step up in cost basis. So if I pass away, my wife gets a step up to the fair market value on my date of death. But then when my wife passes away, our children get a second step up in basis on her date of death. So there's a full step up with a living trust. The one benefit I would say to having a living, one of the main benefits to having a living trust is if you have special situations, the trust allows flexibility in maintaining those distributions. For example, if you have a special needs individual, a living trust allows you to leave their share in a special needs trust. If you have underage individuals, it allows you to specify what age those individuals can control their inheritance. So there's quite a bit more flexibility in a living trust.
Yes.
When you hold title as living trust.
Yeah. The other thing about title that's really important is that, and we're going to go through the documents in just a second, but let's say you have property as a joint tenant in joint tenancy, and you list that property as well in your living trust, but the deed says joint tenancy. Does the living trust trump the joint tenancy, or is it the other way around?
So typically, if clients own title as joint tenants and one tenant deeds their interest to the living trust, it severs joint tenancy. So it exposes the other person who hasn't created an estate plan for their share. I'm not sure if that's what you were asking, Pete, but anytime you put your interest into a living trust, it should sever joint tenancy if done correctly.
Yeah. Well, as a professional fiduciary, for example, when I step into a situation, into an estate, I have to determine first how they have title to the property.
Always.
So do I wear my trustee hat? Do I wear my power of attorney hat? Which hat do I wear to get my legal authority? So that's kind of why how you have title is so important.
Absolutely.
Okay. Guys, just real quick. First of all, 15 more minutes. But also there's a lot of questions, just over this last few months regarding putting properties in LLCs. I think Prop 19 kind of brought that up a lot. We don't talk about that, but do you have anything to say about putting a property into a corporation, essentially an LLC?
Yeah, you have to be careful, because what happens is it can really mess with the property taxes if you don't do it correctly. Also, it can mess with the property taxes if you passed away and your property was in the LLC. The LLC is good for liability protection. It's very important for liability protection, but you have to be careful because a lot of people don't realize that LLCs really can hinder the property taxes in the future. For example, if my wife and I own a property 50-50 and I put it into an LLC where I own 100%, they're going to reassess the property for 50% because it's not proportionate interest. So first off, you want to make sure when you put a property into an LLC, it's proportionate interest. We were doing LLCs because of Prop 19, because we had a lot of parents who gifted their properties to their children to maintain the property tax rate. And then we put it into an LLC to protect the parents' property from liabilities. So we were doing a lot of that. We also use LLCs. We can't do so much anymore with Prop 19, but we call it the legal entity exclusion. It allowed me to transfer millions and millions of dollars worth of property, assessed value property, to children without using the cap. But we can't really use that anymore because of Prop 19. And I'll kind of go over that, Trevor. I don't know if I answered your question.
Well,
yeah, that's fine. Let's go to the next slide.
Well, I think the bigger issue is, especially for this basic estate plan session, is how you hold title to property is not intuitive. You need an attorney to guide you as to how you should hold title. And the more assets that you have, it's one of the burdens that comes with wealth. If you want to do it properly, the laws change, the different ramifications, families are different. So how you hold title to property is just huge. What is a will? We probably know, but let's go through it.
And I'll quickly go through this because I know that we don't have very much time, but we've touched on the will throughout this presentation. It's a document that you put together that dictates where your assets go after you pass away. You're the testator if you create your own will. So you're the creator, which means you're the testator. The executor is the person you appoint to carry out your wishes. And the easiest party to a will is the beneficiary, who inherits your assets.
So that's the terminology.
That's the terminology: testator, executor, beneficiary. And then different types of wills. Holographic will, we touched on that. It's entirely handwritten. No need for a witness or anything like that. Just
no notary needed.
No notary needed. For a statutory will, for example, California has a statutory will where they have this template that is partially typed out and you kind of fill in the blanks. It does require 2 witnesses for the statutory will. A formal will is basically a will most of the time it's an attorney who drafts the will. It's usually entirely typed and it must be signed and signed by 2 witnesses.
Yeah, and the 2 witnesses need just to witness the signature.
You got it. Just to witness the signature, witness that the person signing it was the person who in fact created the will. And then, in my opinion, the formal will is the safest way to go, because when you go to validate a will, if you have an attorney draft the will, a lot of the times there'll be notes that the attorney keeps. They can testify to your capacity that there was no undue influence. So typically I would recommend doing a formal will.
Yes. What is a pour over will?
A pour over will is a different type of will. It's a will attached to a trust. It's a lot different than the other 3. Every trust should have a pour over will. A pour over will allows, if you pass away and let's say you forget to put a property into the trust, the
title, when you say put it into the trust, you mean titled it in the name of the trust.
Exactly. So if you forget to title an asset in the name of the trust and it would otherwise be subject to probate, the pour over will says, don't let it go through probate. My intent is that it allows that everything belonged to my trust. So we can use the pour over will to pour that asset into the trust without going through a full-fledged probate. To be honest, though, in order to do that, you have to file a Hegstat petition, and that still takes 6 months, actually 6 to 8 months now, unless you get an expedited hearing. So, so even that can be as long as a probate.
That's why you want to keep track of your titles to your properties and your assets. Exactly. So important. The holographic will is the most litigated. The second one that's most litigated is the statutory will. What people do is they make cross-outs and put notes in there, and that immediately invalidates the statutory will. Formal will, if somebody just wanted to come in to you to do a formal will, the advanced healthcare directive and the durable power of attorney, what would be your cost, or what would be the client's cost?
For the will itself, we charge $450. For the ancillary documents like the financial power of attorney, the healthcare directive, it's another $450. So it would be $900 total for everything.
Okay, let's go to the next slide.
Perfect. Personal property assets, they actually can be subject to probate, personal property assets. And whether you have a trust or a will can generally help the transfer of those personal property assets. Both avenues, a trust or a will, allows you to specify where personal property items go, like jewelry, antiques, furniture. So personal property is things that are tangible, and having a trust and a will can dictate where those assets go upon your passing. Actually, in most trusts and most wills, they do have like a letter of intent or a personal property memorandum where you can actually handwrite where those items go. So you don't have to pay to keep updating it. You can actually handwrite where certain aspects of those personal property items go.
Yeah, and you can, one of the family disputes a lot of times is on personal property. So you may want to make the executor or your trustee the dictator, the final arbitrator. Hopefully the family can work it out themselves, but have somebody who could say, okay, this is enough. This is the way it's going to go.
I'm dealing with the potential litigation. We might go to litigation for various things, but it started because the personal property items in a property were to be divided 3 ways. And one of the siblings was living there and basically sold off all the personal property items and hid the others. So a 5-6 month trust administration is turned into probably a year to year and a half. So it can really be a problem if you don't specify certain things.
Yeah, and if you have jewelry and things like that, at some point in your life, you may want to give it away during your life.
Yeah.
And if they don't appreciate the jewelry that they received, then you can exclude them from the rest of your estate. Mm-hmm. Let's go to the next slide.
So the law that's been getting the most steam in the past few months is the Prop 19, the property tax rates in California. But before I get into Prop 19, let me kind of just briefly explain what Prop 13 is. I'm sure we all know Proposition 13. I believe it was implemented in 1976. What it did is it adopted what we call the acquisition value method of property taxation. It limits the amount our properties in California can increase to 2% based on the previous year. That means, for example, if any of you bought a property in the 1980s and you're only paying $1,500 in property taxes for an $800,000 property, that's because of Prop 13. Now, Proposition 58 allowed us to transfer property to our children without reassessment of property taxes. And the way it worked was your primary residence can transfer to your children, no reassessment of property taxes, doesn't matter what the value of the primary residence is. All other properties can transfer to your children with no reassessment of property taxes, so long as the assessed value of all those other properties collectively was less than $1 million. Now, keep in mind, assessed value is a lot less than fair market value. I had a client who had 5 properties. The fair market value for each one was on average $500,000. The assessed value collectively was just over $1 million. So basically you could transfer a lot of property to your children. They got to keep your property tax rate. It was great. Proposition 19 changed this. Now with Proposition 19 in effect, you can only leave your primary residence to your children with no reassessment of property taxes if they use it as their primary residence. And that's not practical in a lot of situations. On top of that, any other property you own outside of your primary residence will be reassessed upon the transfer to your children. So we don't have that $1 million cap on those other properties any longer. Capital gains tax.
We went through, just so you know, we went through that in the first session. You may want, and I believe the estate tax exemption is up for debate in the Biden administration. We don't know what's going to happen. And what does sunset mean?
It's going to end. So the Tax Cuts and Jobs Act was implemented in 2017 and it was passed in 2017 and put into effect 2018. That was Trump's bill, and he doubled the estate tax exemption from 6 million, from 5.5, he doubled it to $11.5 million. Yeah. So what happens was that bill is only set to go till the end of 2025, which means at the end of 2025 and the beginning of 2026, the estate tax exemption is going to drop from 11.5 to 6 million, adjusted for inflation, of course. However, President Biden is most likely going to drop it before 2025. That's just my assumption. And he's threatened to drop it to as low as $3.5 million. So we just don't know where that's going to be in the future. But I do think it might be changed by next year.
Yeah, and I believe everybody understands the gift tax issue about 15,000, but they don't understand the tax basis of making a gift, and they don't understand that 15,000, you can give a lot more than 15,000.
Yes. So your lifetime exemption amount right now, today, is I could gift $11.5 million to anybody I want, and I don't have to pay any taxes. I just have to file a gift tax return called a 709, and it reduces my lifetime exemption amount to 0. And that's where the complication gets. So let me kind of just briefly explain that. You can gift $15,000 per donor per donee. So to any individual person, you can gift $15,000, and you don't have to file a 709 gift tax return and report it to the IRS. If you make more than a $15,000 gift to any individual, let's say I make a $100,000 gift to an individual, I have to file a 709, and all it does is nobody pays taxes. It just reduces my $11.5 million estate exemption to 11.4. So that's kind of how that works.
So the example that you used about the $50,000 stock that was $1 million at death, what would be the cost basis if you were to gift that $1 million worth of stock during your lifetime?
50,000. So I always tell clients, it's better for your children to inherit the assets as opposed to you gifting it to them before you pass. Because if you gift any asset to them before you pass, they retain your cost basis.
That's why when you have all of your assets, list your assets, put in the title, put in the cost basis, put in the market value, and that way you'll kind of understand what is your net worth, what's the gross value of your estate, and it's an easy way to see how you're having the title, so you understand later on when you planning on making gifts, you'll know what the proper items are to make a gift.
Exactly.
So we have a few more minutes, so I don't know how many more slides are left.
I think the rest of the slides you're probably going to cover later.
Yeah, but these are the main components of an estate plan: the durable power, the advanced healthcare directive, the living trust, that's the will, and that's the $2,000 basic package along with the transfer deeds, etc. Right, Davinda?
You got it correct. The only other additional fee is the recording fee for any deed that goes to the county recorder.
Okay, great. Next slide goes into each one of these, but what we're going to be doing is we have an entire hour and a half on living trusts. So we'll get that in the future. Next week, go to the next slide. Let's talk just to briefly spend a minute on this.
And so the way it works is a will is, and you probably already caught this by our conversation, but a will is subject to probate. A trust avoids probate. Remember, we went over the advantages and disadvantages. But the way it works is if you have a will and you have more than $50,000 in real estate, it is subject to probate. Less than $50,000, no probate. This right here is my fault. This $150,000 is actually increased to $166,250. So if you have less than that, there is no probate. If you have more than that, it should be subject to probate unless you have a trust in place.
So when you have a joint tenancy account, that is a non-probate asset. So you don't list that in your 166,000.
Exactly.
You don't list your assets out that you have in a living trust because it's not subject to probate.
You got it.
It's assets that you own individually in your own name with no POD or TOD at the end of it.
Exactly. It's basically, yeah, you said it exactly right. So it's anything that you have with no transfer clause, like a POD or a TOD, anything that's not in a trust and anything not held jointly.
Okay. So you have a probate estate. Every one of us do. Mm-hmm. And you want to keep it below 166,000.
Correct. If you want to avoid probate.
Okay. Let's go to the next slide.
So
there you go.
There we go.
Yeah. So if you want to schedule a free consultation, Davinda is there, and no cost or obligation on the first meeting, which, by the way, is really rare in Orange County, that an attorney is willing to give you an hour of his time at no charge. So good for you, Davinda.
What is an ITF account? Does that avoid probate?
What is that, Trevor?
ITF. I don't know. I don't know what it stands for.
ITF. I don't either.
Yeah, I'm not sure.
Okay. All right. Well, thank you, Davinda. That was very thorough, very well done. Pete, briefly, what can we expect next week regarding our preparing for incapacity?
Next week, I believe, is from my point of view, is the most important session of the 8 weeks, because we are going to be talking about medical, the Advanced Healthcare Directive, and it has nothing to do with money. And then we're also going to do the durable power of attorney. So those two documents, even if you have a trust, those two documents are probably the most important if you suffer from some sort of incapacity during your lifetime.
Excellent. So we get to talk a lot about death, dying, dementia, all the fun stuff.
Oh, I love the topic.
Yeah, you guys will love it. Okay, thank you. Thank you, Pete and Davinda, and everyone for joining. We will see you next week on Wednesday if you're in the It's Your Money. And then for It's Your Estate on Thursday at 10 o'clock.
Thank you, Davinda.